Hello everyone, I'm Allie James, the Program Manager of the Chicago Student Invention Convention, a kindergarten through 8th grade invention program of Chicago Innovation. Thank you for attending today's webinar, A Beginner's Guide to Understanding Intellectual Property. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, feel free to submit them by using the Q&A widget at the bottom of your screen. We will monitor the questions coming in and try to answer these during the webcast or at the Q&A session at the end of the presentation today. If a further answer is needed or if we run out of time, your question will be answered later via email. A copy of today's slide presentation and the Guide to Intellectual Property document that we discuss is available in the resource widget in this presentation. CSIC teachers have access to this document already in your teacher account on our website. We encourage you to download any resources or links that you may find useful in the resource widget today. For common technical issues, click on the Help widget at the bottom of your screen. A quick tip, if your screen freezes or you encounter other technical issues, press F5 on your keyboard to refresh the page. If you continue to have technical issues, please send us a note using the Q&A widget and our staff will assist you. Now to introduce our presenters today, Michael Parks and Sartouk Moussavi. Michael Parks is a partner with Thomson Coburn. He counsels clients on patent and trademark issues and represents them in federal courts across the United States. He has significant experience litigating patents in a wide variety of technical disciplines and has successfully handled matters related to the litigation of complex electrical engineering and software-based technologies, such as mobile computing, cellular communications, global positioning, and interactive television applications. Sartouk Moussavi is also a partner with Thomson Coburn. He represents clients big and small in a number of industry sectors, and his practice covers the spectrum of IP law, including litigation of patents, trademarks, copyrights, and trade secrets, advising clients on protecting and enforcing their brands, patent, trademark, and copyright prosecution, with a specialization in design patents, conducting IP due diligence for companies involved in M&A, and general counsel to clients regarding their business and IP. Welcome to both Michael and Sartouk, and take it away.
Hello, my name is Michael Parks. My partner Sartouk Moussavi and I are very happy to be with you today to discuss A Beginner's Guide to Understanding Intellectual Property. Our world today is driven by innovation. You see it everywhere, from our Zoom video conferences during the pandemic, to our Instagram pages, to our TikTok posts, to our automated appliances that now run our lives. We live in a world full of constant innovations. And as we'll explain today, that's where intellectual property comes in. We're going to cover some of the basic forms of intellectual property: patents, trade secrets, trademarks, and copyrights. We're going to cover how they're relevant to innovation and to business today. We're also going to go over some practical considerations based upon our years of experience in handling intellectual property matters. And of course, we'll be happy to answer any questions and answers that you may have. So the first thing we should do is to explain what is intellectual property. It is such a clunky word and such a clunky expression that we just call it IP for short. And in a general way, a good way to think of it is that intellectual property is any invention, any work product that is the result of your creativity or your ingenuity. It can be technology like an electrical circuit design. It could be how you make something. For example, how do you make a very strong paper plate that won't fall apart when it's loaded with food? It could be a brand name. It could be a secret process or formula like the Coca-Cola formula, or a book, a play, a song, a rap, anything that is written down in creative. It is anything and everything that results from your mind's creativity. That's the intellectual part, the creativity part. The property part is the fact that it is your property because it comes from your mind. So what do you do to protect your IP? Well, there's several different ways to do it, and as we'll discuss today, that they overlap. So for example, let's take an iPhone as an easy way to illustrate how the various forms of IP overlap. An iPhone's protected by patents. It protects the way it functions. It protects the swiping up and the swiping left and right that it does. It protects how the data is transmitted. It protects how it has the wireless connectivity. It protects all of those functionality things. That's what the patents protect. The trade secrets are similar in that they can protect technology, but they can also protect things like what you paid for your products, anything that is secret and that you get some value from by the fact that it is secret. That's all protected by your trade secrets. And your trademarks are your brand names. It's the Instagram, it's the iPhone, it's the Kleenex, it's all the products that you see in the world today. The copyrights, it's how you express stuff. It's the computer code that drives our technology. It's the images, it's the videos, it's the songs. So as you can see, all of these things are intellectual property and they all overlap with each other.
Okay, and so with that, I'll start, and my name is Sartouk, as Ali and Michael said. I'm an IP attorney with Thompson Coburn, and I'll get into a little more detail about, patents, what they are, how they work, and sort of just some key pointers that would be, I think, useful for you guys to know in your role as educators and otherwise. So, heard a lot about it. What is a patent? A patent, it says it on the screen there. It gives you the right to exclude others from making, using, offering for sale, or selling your invention or importing your invention into the U.S. And so an important thing to note off the bat with that is that patents are exclusionary rights. So that means that just because you have a patent doesn't mean that you can actually practice your invention. I know that sounds counterintuitive, but a good way, probably a simple way to illustrate what I mean by that is, if you go back some years when the person who came up with a pencil, right, there was some wood, you put some lead in it, and you're like, oh, wow, we can write on paper with this. And so he gets a patent on a pencil. Some years later, someone comes along and says, okay, well, this pencil thing is cool, but, I made a mistake. I want to get rid of that mistake on the paper. I'll call it an eraser. And we can put that on the end of the pencil, and no one's ever done it. And so that person applies for a patent for an eraser and gets the patent because it had never been done before. Now that person has a patent on the eraser, but it doesn't mean he can actually practice that invention if it's on the end of a pencil, and the pencil is under patent protection. And so that's just sort of an illustration to say, patents give you the right to exclude others from practicing your invention. It doesn't necessarily give you the right to practice your invention. So on practice, a lot of times, you will have that right, but that's just something to keep in mind. So there are different kinds of patents. There's 3 of them. We only included 2 on the screen because utility patents and design patents are the vast, vast majority of all patents. There's a third kind of patent, which is a plant patent, which we didn't include because, quite frankly, it's just not something that's utilized too often. And so we're focusing here on utility and design patents. So what are they? What are the differences? A design patent protects the ornamental design of an article of manufacture, of a product, sort of its unique external experience, aesthetic, its shape. One example I'll probably use as I talk about patents because I think it's pretty easy to understand, and we also have a client that makes a lot of these and we deal with them a lot, is water bottles. And so let's say you have a water bottle, a cool new bottle cap that looks different than any other bottle cap that's been out there. You can get a design patent on how that looks. A utility patent, on the other hand, protects the function, the way it works. And it doesn't necessarily have to be limited to an article of manufacture. It can be steps of doing something. It can be a method. It can be the process of manufacturing something. And so Utility patent protects more of the function, design patent more of the aesthetic. And so in terms of the scope of protection, the design patent, how you determine the scope when you look at a patent. And I have some examples of patents that we'll show you just so you can see what it looks like. But the scope of protection of a design patent is determined by the figures in the patent. So you look at the patent, and what the figures are sort of dictates what the rights are. And so if you have a product that falls, that looks just like the figures, well then you may fall within the scope of that patent, and therefore you might infringe, or vice versa. If you have the patent and someone else falls within it. The utility patent is mostly words, or at least words are going to define the scope. But there are also going to be figures in there, but the figures kind of give meaning to the words you're describing, sort of the way something works. Okay, so in terms of term, how long a patent lasts, if you apply for a patent and it issues, you get it through to issue, how long do you have those rights? It's a limited monopoly you get with the patent. A design patent, you get it, for our purposes here, it's 15 years from issue. So after it issues, you get 15 years from that date, and that's how long it lasts. After those 15 years, you no longer have those rights, and it's to the public domain, and that's why, well, the next example, utility patents are 20 years from filing date. So the difference there is between, for design patents, it's after it issues for 15 years, and the reason it says 14 or 15 is that the law changed. So there's patents that are before May of 2015, I believe it is. It's 14 years, and then they extended it for a year. So forever, it's 15 years. But for example, that's why you see generic pharmaceuticals, right? So those are oftentimes covered by patent, and then the term expires, and then it's in the public domain, and then you can copy it. So here's a quick summary here. On the left, we have design patents. On the right, we have utility patents. And so design patent, it covers the ornamental figures, in images and in figures. I'm sorry, the ornamental design, the aesthetic design, and it's covered in images or figures. For utility patents, it's the concept. It's the way something functions, and that's done in words. We see the life of the patent as we discussed there, in terms of time to issue. So this is something that's frequently asked. Patents take time. Okay, utility patents can take a long time. On average, it's 2 to 5 years. It's not quick, and they're often costly, especially utility patents. Part of the reason for the additional costs for utility patents is it just takes more attorney time, because it's just more work, essentially. And there are additional government fees, but a lot of it is actually in the amount of time it takes to prepare the application. And that's not to minimize the value of design patents. Design patents can be very valuable, but they can, just basically not take quite as much time, and so they can be quite a bit cheaper sometimes. An advantage to design patents that don't exist with utility patents, and this is something, when you have an invention, a lot of times you're focused on the innovation, but you want to sort of convert it into a business, and we'll touch on some of these topics, both in this section and some of the other ones, but design patent, you have an advantage that doesn't exist with utility patents. It's just because the way the law is written. If someone is liable for infringing your design patent, rather than having to prove up their damages, meaning how you were harmed and how you should be remediated for the infringement, there's a statute that says you can choose to just recover the defendant's profits. So if someone has infringed your cool water bottle design and you prove that, well, then you can just get all of their profits as your damages. And so that can be cheaper. It can oftentimes be higher than it might be in a utility patent. In a utility patent, it can be significantly broader in scope. And so, someone that likes your cool new design, they might be able to tweak a few things in terms of the look and aesthetic of it, and potentially get around your patent. Whereas if you describe it in a utility patent sense and you get broad coverage, well, that can cover different aesthetic designs of the same functionality. So here's an example of parts of a utility patent. You know, so a utility patent will be some number of pages. This is the cover page will look like this thing on your right. You see on the top right there is a number there, 10 million, you know, 10,875,042. That's the patent number here. The date below that is when it was issued. So this is a recent patent issued. This you know, last month. This is one that we did. You know, the title is bottle closure. The company that applied for it is there below that. The inventors. You see the file date, and so that's the front page. You then have a number of figures and a bunch of description that sort of talks generally and specifically about your invention. And so one of the figures is there, as you see. It's kind of blown up and has the different parts, you know, sort of with numbers that describe it. And in the specification, in the body of the patent, there's going to be detailed sort of describing of, you know, what number 130 is and how that works into this. And, you know, because you're taking this physical, mechanical product in this case, and you have to put it into words ultimately what it is that is your invention. That's what gets you to your claims. Claims are at the end of the patent. They're numbered. And this is, in the middle here, is a portion of Claim 1, okay? And so that's where it says what is claimed is, and, you know, this sort of the way it works, a patent claim is one sentence broken up with semicolons, and it's just sort of the way that it's always been done and the way that it has to be done. And I know it's probably hard to read there, but you're describing there. So bottle closure for releasable attachment to a bottle, and for providing hydration to a user, the bottle closure comprising. And then you describe the different elements. A drink spout adapted and configured, you know, so I won't get into it too much, but, you know, you see the first few words, a pump mechanism, a trigger mechanism, operatively connected. So you're describing how this thing works, okay? Now the next slide is a design patent, and this is for the same or similar product, same client, same company. This one issued months earlier. The design patents typically issue faster. You see the patent number there. A design patent will have a D in front of the number. And in this case, so just, you know, for your knowledge here, in a design patent, when there are dashed lines like there are in the bottle, that means the bottle is not part of the claim, which means if someone comes along and copies the bottle cap and the way it looks just like that, but puts a different bottle on it, well, that's still infringement because we're not claiming the bottle in this case. We're only claiming the cap. But, you know, so the caps here are similar or the same. They don't look identical, but that's because this figure here in this one is just a little bit more generically drawn. It's for this product. But in this case, if you know, it was quicker to get, it was cheaper to get, it was easier to get in terms of back and forth with the patent office, but there are easier ways for a potential infringer to design around it, right? If they slightly tweak this trigger thing, this thumb trigger thing in a different shape, and maybe move the misting spout over and add some, they could potentially have an argument that they don't infringe. Whereas here with this one, we're describing how this works, right? If it's still kind of a thumb trigger and there's a misting spout on a bottle, we can still cover potential infringers. And so that's some of the pros and cons there in terms of the broadness, the potential broadness of a utility versus a design patent. I touched on the timing, so I won't spend too much time on that. Utility patents take longer typically. But one key takeaway, I guess, from this slide would be they can be expedited. So both design patents and utility patents can be expedited, and it's significantly faster. It's just more expensive. It costs more. But that is an option if it's, you know, something super valuable. You want to bring it to market, and you want to be able to enforce it faster. That is an option. So when, you know, this is relevant, I think, to the students and beyond. When should an application be filed? In an ideal world, you will file your patent application before you disclose it to others or before you offer it for sale. And the reason is, and this sort of gets into the next slide, one, it's just better to have your application on file before showing anyone, because then there's no risk of someone stealing it or rushing to the patent office and getting their own patent on the thing that you invented. But also there are other potential ways that can have an impact, including for foreign rights, and I'll talk about that in a couple slides. But it's not always feasible, because one thing for students or small businesses, there's oftentimes not the means. Patents are not cheap, and so you want to know, is this likely to, or does this even have a chance to succeed? I want to go out and see if there's anyone interested in this product or any buyers. And so how do I do that? Well, one sort of way to thread that needle is with an NDA, a non-disclosure agreement. And Michael will touch on this more in the trade dress section next. But a non-disclosure agreement or a confidentiality agreement is an agreement that the person or the company that you're showing won't show anyone else, and they're bound by certain conditions. If you have that in place, that gives you certain benefits and rights in case someone does sort of steal your thing beyond just the patent claims. And one of them is in this way. The one thing everyone should take away from this, if nothing else, because this is going to be very relevant, and the students should know this, and anyone really should know this. A lot of people don't know it. If you present your invention to the public, put it out there, including on YouTube, for example, especially if it's a public YouTube link, or you have it out there, you offer it for sale somewhere, that starts your clock to getting your patent application on file. If you don't file your patent application within 1 year of publicly disclosing or offering it for sale, you then lose your patent rights completely. It goes to the public domain. So if you wait 366 days from when you first show it publicly or when you first offer it for sale, your rights are deemed lost at that point. And that's something everyone should know. So once you put it out there, if nothing else, mark that date on your own calendar and say, I need to talk to a lawyer or someone that knows about, filing something within a year from this date, or I could potentially lose my patent rights. And I'll just touch real quick on foreign patents. I know, it might be a little bit beyond the scope here. Okay, I see a question just came in. We'll get to that question, I think. But okay, so foreign patents, I'll just touch on this real quick. Every country has its own patent system. So if you have a U.S. patent here, you can't use that to enforce, in China or in Korea or Mexico or wherever else. You have to have IP in those countries to be able to enforce in those countries. And so that's relevant, not only just for the knowledge there, if someone has some cool idea that they think, hey, I need to, have this protected in maybe the country where this product or this thing is going to be manufactured or where it might be popular, but they should be at least thinking about foreign rights. And the reason that's relevant is, so in the U.S., as we just talked about, you have a year grace period, they call it, to file your application. In other countries, there actually is no grace period. In not all, but many other countries, there is no grace period at all. So once you show it publicly or once you offer it for sale, if you don't have your application on file, you lose your rights completely. So that's just something for people to keep in mind. Now, the one thing with the foreign rights is if you have filed your U.S. application before showing it publicly or before offering it for sale, so then, you don't show it, you file your application, now you show it, you have 6 months from your file date, if it's a design patent, to file in these other countries. There's a grace period for that. So you still have to have your U.S. patent on file before you show it publicly or offer it for sale. But once you have your patent on file, then you can show it publicly, and then you have a year, if it's a utility patent, to decide whether you want to file in Korea or Japan or wherever else it might be. So with that, I'll pass it on to Michael to talk a little more about patents and then on to trade secrets.
Okay, thank you, Sartouk. Okay, so first let's talk some specifics about applying for a utility patent in the U.S. And I know a question came in about what is a provisional application, and we'll get to that in this section. So in the U.S., there are two types of patent applications that you can file. One is a provisional, and the other is a non-provisional. And there's advantages to both, and there are significant differences between them. So first, a provisional. A provisional application is designed in the situation where an inventor comes up with something, but they may want to spend more time perfecting their invention. So for example, they come up with a new pharmaceutical formula, but they want to be able to test it more and tweak it more, and so they're not yet ready to file their full-blown patent application. But that being said, they want to lock in their rights now so that somebody can't beat them to the punch and file ahead of them. In that kind of situation, you can file what's called a provisional application. There's no set form for it. It could be anything. It could be a PowerPoint presentation. It could be a white paper or a technical bulletin that you write. There's no format for it at all. And it really is a placeholder for your real non-provisional application. What happens is if you file the provisional application, it sits there and you have a year to replace it with a non-provisional application. And you can spend that year tweaking your invention, perfecting your invention. You can spend that year deciding whether or not you think it's worthwhile to spend the money on a full-blown patent application. Because your provisional can be any form you want, you can file it fairly cheaply, and then again, make the decision if you want to spend the money on the full-blown patent application. What's very important to note is that your provisional applications are automatically deemed abandoned, which means they go away in a year if you don't replace them with a non-provisional application. These provisional applications they're never published. No one knows about them unless and until you file a non-provisional application that ultimately is published or granted. Now, it all sounds like a really good thing to just go put this provisional application on file and save a bunch of time and money and spend a year just waiting around and figuring out about a provisional application. But there's a catch to it, a very significant catch to it. What happens is when you file your provisional application and you get that locked-in filing date, let's say of today, of January 27th of 2021, that locked-in filing date is only good for exactly what you presented in your provisional application. If you add new material to it, new technology to it, that new material, that new technology is deemed to be filed when you add it to the patent application. So if I perfect my patent application during the next year, add a bunch of stuff to it, and it's now great, all that new stuff I added has a filing date of the day that I added and filed it. It does not carry my provisional filing date. And so for that reason, if you're able to spend the money on it and you have your invention ready, we always advise people to make your provisional application as complete as you possibly can, because you want to minimize the risk that someone's going to come along in the meantime and come up with the idea that you want to add within the next year. So it's important to keep that in mind. Another thing that's very important about the provisional applications is that once they're on file, you can mark your product as being patent pending. And that's very important to deter people from copying you. And so if you want to go out to market and you don't think you can wait for your non-provisional application, you definitely want to file a provisional to start with. It lets you market patent pending. It locks in certain rights, and it's a nice way to deter people from trying to steal what you put on the market. Okay, the other form, the non-provisional that I touched on, now this one's a lot more complicated. This is the real formal application that must adhere to the very, very specific, intricate patent office rules. This cannot be the PowerPoint or a technical bulletin. This requires what Sartouk showed you in the prior slide, a very detailed written description of your invention, including diagrams and figures that would help explain it, and these numbered paragraphs at the end, which are your claims, which actually define what your invention is. These non-provisional patent applications are examined by a patent examiner who knows the technology, and the patent office is set up in various art units. And so if I file a patent application on a water bottle, for example, it's going to be examined by folks who specialize in mechanical inventions of that nature. If I file a patent application on a circuit design, on the other hand, it's going to be examined by electrical engineers who have a background in circuit design. And so the point of it is for someone who knows the technology and is skilled in that art to make the decision as to whether or not you should get a patent for your invention. And what the patent examiner does is he or she does a search for what's called prior art. And prior art is just another term for inventions that came before you. It could be anything. It could be something on the internet. It could be a physical embodiment. It could be a paper that's written. It could be your invention if you don't follow the rules and you put it out to market more than a year before you file for a patent application. So the patent examiner looks for prior art, looks for things that may be similar to yours, and then says, hey, is what this person did different enough to qualify for a patent? Is it something that's new in the art? And if it is something that's new in the art, is it something that would not have been obvious to do based upon what's out there already? And so it's a very detailed analysis that takes place by the patent examiner, and they make a decision. They may allow your application, they may reject it, or they may ask you for more information. It is very rare that you would ever get your patent application allowed on the first try. Usually what they do is they tell you, I found this stuff that I think makes your patent or your invention unpatentable, so you tell me, patent applicant, why what you did is different from what I found. And I'll take a look at it, and I'll make a decision and decide whether or not I agree with you. And there's that back and forth that goes on where you try to persuade the examiner, yeah, I know that there's this circuit out there that may look similar to mine, but it's different because that circuit that's out there has an efficiency ratio that's much lower than mine. Mine's much more efficient. Mine requires fewer components that are not going to break as easily, and so it's different. And for that reason, I should be allowed a patent on my new circuit design, my new invention. If the patent examiner ultimately does not agree with you and keeps digging his or her heels in, they'll issue what's called a final office action, which means this is the final time they're telling you they're not giving you a patent. And you have a choice at that point. You can try again to persuade them, but they've already told you that's their final decision, or you can appeal it. And if you appeal it, it goes to a body within the Patent and Trademark Office, goes to a trio of judges who also are engineers, and they make a decision as to whether or not they think the patent examiner was right or wrong in rejecting your application. If they still reject your application and you still want to push it further, you can appeal that decision by that trio of examiner judges in the patent office. You can appeal that to a court and have a court make the decision as to whether or not you're entitled to a patent. What you typically see happen is for those inventions that a company thinks is critical, they will take this appellate route all the way through because it's important. Other times people don't, and they just give up. And what they may do is file what's called a continuation application, which is what you're saying then, okay, fine. You know, I'm going to stop with this one, but I'm going to continue it with another one. And I'm going to start the process all over again and see where I end up there. So as you can see, it's a very, very complicated back and forth that goes on with the Patent Office for these non-provisional applications, which is why they take so long in part and why they can be so expensive. So let's turn briefly to trade secrets. And again, trade secrets are those things that have their value by virtue of the fact that they're secret. A good example is the Coca-Cola formula. That formula has been around for over 100 years. If Coca-Cola had tried to patent that formula, they would have had to disclose the formula in their patent application. And that patent would have long expired by now, and anyone and everyone could make Coca-Cola as they saw fit. But Coca-Cola made a very smart decision and said, I am not going to try to patent this formula. I'm not going to tell anyone what my formula is. I'm going to keep it a secret. And as long as no one else can figure it out and make it on their own, it's going to stay a secret. And for over 100 years, no one's figured it out. I mean, they tried to come close, but in my opinion, nothing's better than Coca-Cola. So, you know, you see that sometimes it's not always the best thing to get a patent. Sometimes you want to keep it as a trade secret. Your lists of your customers, your suppliers, things like that can be your trade secrets because they help you advance your business, and you don't want your competitors to know that your vendors give you a 15% discount if you buy from them on Thursdays. You want that kept a secret to give you a competitive advantage. You know, the Krispy Kreme donut recipe is a trade secret. No one knows what that is, and it's getting, you know, a lot of popularity. A lot of the food recipes are trade secrets. So you know, you can see that it's not all about patents. If you have something that you can keep secret, you may want to keep it that way. And a good way to look at it is whether or not it can be reverse engineered. So if I put some electronic circuit on the market, somebody can take that apart and reverse engineer it. They can't do that with the Coca-Cola formula as secret, as easily. So this becomes the rub, so to speak, between patents and trade secrets. Because remember, if you patent it, you have to disclose it, and then it can't be a trade secret. So you have to make that decision as to which way you want to go. Now, it's important to note that one product can have both patents and trade secrets in it. And the iPhone, we'll pick on the iPhone again. It's a very good example. The source code in the iPhone is a trade secret. Apple hasn't told anyone what the software code is that makes the iPhone run, and they're not going to tell anyone what that is. That is their trade secret. At the same time, they have a bunch of patents on their iPhones over the functionality, because for things that someone could take the iPhone apart and design and figure out how to do, Apple has made the smart decision that let me patent that before someone else figures out how to do it. And what I will keep to myself as secrets are those things that people cannot figure out how to do. And again, as with the example of an electronic circuit versus perhaps a Coca-Cola formula or some other chemical formula, whether or not you treat it as a trade secret or a patent is going to depend on your particular business and the particular technology at issue. It is a case-by-case decision that often is best to consult with an attorney on. And I'll turn it back to Sartouk for trademarks.
Okay, that sounds good.
I'm sorry.
So
So before you go to trademarks, I'm sorry. Let me emphasize one more thing. I apologize. I turned it back too soon. With trade secrets, we mentioned non-disclosure agreements before. It is absolutely critical that under no circumstances whatsoever do you ever disclose a trade secret to anyone without them having first signed a non-disclosure agreement. It doesn't matter what the circumstance is. It doesn't matter who the person is. It doesn't matter how many times they guarantee you they will keep it secret. Under no circumstances should you ever disclose a trade secret to anyone unless they have first signed a non-disclosure agreement. And so with that, I'll turn it to Sartouk for trademarks.
Thanks, Michael. So now we'll turn to trademarks, one of the different types of IP. And these things are all somewhat, related in the sense that, they can work hand in hand. And we'll talk about why trademarks are relevant to, even for inventions and things of that nature, where the trademark itself is not protecting the invention, but it may be protecting the business that is founded on the invention. So what is a trademark? Trademark is a word, a symbol, a design, really almost anything that is a source identifier of a product or a service, right? So if I say Apple for consumer electronics, I think everyone will associate, the company that we're talking about that's known as Apple. That immediately comes to mind. Kodak is another one. I mean, assuming everyone here knows of Kodak, I'm not even sure if they're around as much these days. I think they are, but not quite as prominent as they used to be. But Kodak is a good example that we'll get into because of the name itself. Microsoft, you relate that pretty quickly to computers, Charmin for toilet paper. So a trademark is a source identifier. And it really doesn't have to be a name. I mean, it can be a logo, right? So if you see a specific, maybe just an F in blue, background, a white F, you probably associate that with Facebook. And so the way to think about trademarks is like a core sort of reason they exist and why we provide them is something that you get protection on in terms of IP is to protect consumers. So for example, if I go to a shoe store and I see a shoe with a Nike check on it, I have, as a consumer, a certain expectation of the quality of the product I'm receiving because I'm familiar with Nike and I like their shoes and I have an expectation of the quality, right? And so it's to protect consumers, but it's also to protect businesses and industry in order to sort of cultivate their brand and associate their product, their service with a specific source identifier. And it doesn't even necessarily have to be a name or a word or a logo, although those are the most frequent. But if I said, hey, there's a delivery truck coming down the road, it's brown, and the man, the woman getting out is wearing all brown with a brown hat, I think most people would assume that's a UPS truck. And UPS thus may have rights in brown, uniforms as it relates to shipping, logistics company, for example. And so that's the general sort of understanding of a trademark. And they work hand in hand in this case with if you have an invention, because typically an invention, the inventor wants to, if they can, make something out of it, make it into a business. And so it's how do I market this thing? I need to pick a product name, or I might need to pick a business name that sells this product or service. Or it doesn't even have to be related to an invention. It could be a restaurant or really any sort of brand. And so that's where trademarks come in. So generic names, and we'll get into this a little more on another slide, but generic names, like you can't get a trademark for chair, right? Everyone understands chair to be chair. That's not something that's a source identifier with a specific company or a specific source. Computer, car, these can't act as trademarks. You can't get them as trademarks. So one thing that is different between patents and trademarks is that trademarks arise out of your using of the mark. And you don't actually necessarily have to get a federal registration in order to have rights. Whereas in patents, if you recall, if you don't file your patent within 1 year of public disclosure or offer for sale, you lose those rights. Trademarks, that's not the case. Trademarks, when you start using your trademark and you start offering your product under this name or your restaurant under this name, and consumers start associating your services, your restaurant, with the name of your restaurant, well, you're developing trademark rights. But there are significant advantages to getting a federal registration. For example, one of them is nationwide use. If you don't have a federal registration, it's based on geography and sort of how far outside of you, where you are physically, do consumers associate, your goods and services with your trademark. Whereas if you have federal registration, it's a presumptive nationwide use. There's damages, benefits, and others. So it's highly recommended in most cases to get a federal registration if you are trying to build a brand. When you see a TM symbol, you often see that. That means the entity is claiming it as a trademark. But it likely means, it should mean that they don't have a federal registration. If they have a federal registration, that's where the circle R comes in. The circle R indicates that you have applied for it with the U.S. Patent and Trademark Office and you have received the registration. You're putting sort of the public on notice that you have this federal trademark registration. So an important aspect of trademarks is to choose wisely and, upfront choose wisely. A lot of times you'll see people or companies really sort of hone in on a name. They just love it. It sounds great. It's perfect. They invest a bunch of time, money into branding it, and they didn't really look into it at all. And they start to take off, and things are going well. And next thing you know, they get a cease and desist letter. Someone has had this or a similar mark for 10 years, 5 years, whatever it might be. And now they're faced with the decision of, do we have to actually rebrand, spend a bunch of money and rebrand, or do we have to fight this in court? So it's important to choose wisely up front. And so the first bullet point there is sort of a spectrum of strength of a trademark. We talked about generic cups, chairs, cup, chair, things like that. You can't get toilet paper. You can't get a trademark on those. Fanciful is a made-up name, and that's where Kodak comes in or Google comes in. It's literally a made-up word. And so that's a very strong mark because people are going to associate your mark with you when you made it up. Arbitrary is not as strong as fanciful, but it's strong still because it's a name that is not really associated with the goods or services. For example, Apple, even though Apple's a known word, when you use it with electronics, that's a stronger mark because there isn't a connection between the word and the services or goods that are provided. And descriptive and suggestive are weaker as you go down. For example, a suggestive mark might be Netflix for streaming services. Netflix. It's not generic, but there's a suggestion between the connection there. And descriptive is even weaker than that. Maybe cold and creamy for ice cream, for example. It's not generic, but it's not strong. And so it's important to sort of find how you want to brand it and then sort of go into it eyes wide open. And so with that, it makes, we highly recommend that you or a lawyer or someone do research up front so that we don't get into this, we have to decide whether we want to rebrand, now that we're sort of already all in. And so do it up front. Google searches are useful because you don't have, as we said, someone can have rights in a word even if they don't have a federal registration. So Google searches are helpful to sort of identify some of those people or those companies. USPTO searches are useful because that tells you who is out there with a federal mark, but it's not sufficient either because there might be someone out there that doesn't have a federal registration. So both of those should be done. In an ideal world, you consult legal counsel about a comprehensive trademark search to see whether it would be useful. And ultimately, if it makes sense for you to potentially go forward with that. And I think that's the last slide on trademarks, and I'll pass it back to Michael. I know we have about 10 minutes, and we want to make sure we can get to your questions. So, Michael, go ahead and copyrights.
Thanks, Sartouk. Okay, so copyrights are things that protect original works of authorship. Books, poems, songs, software, movies, pictures, things like that are protected by copyrights. People often say, I want to copyright something, or how do I copyright something? Here's how it works. You have copyright protection the second that you fix your creative work in a tangible form. And by that I mean you write it down on a piece of paper, or you put it in a computer. Once it is inscribed in something tangible, you have copyright protection. So for example, a live parade is not the copyrightable work. It is the film of the live parade that's the copyrightable work, because that's when it's fixed in the tangible medium of expression is what it's called. So copyrights, they don't protect facts. So the names in a phone book, for example, that alphabetical listing, that is not protectable as a copyright because that's just a fact. What copyrights protect are the way of expressing something. So the prose in a paragraph is protected by a copyright. The notes in a song are protected by a copyright. The way that something sounds or is written or expressed or appears is protected by a copyright. If someone else copies what you created, then yes, they have infringed your copyright. But, and this is a really important thing to note about copyrights, independent development is what's called an absolute defense to copyright infringement. And by that I mean that if someone creates a work independently and they can prove it, even if it is identical to your work, they don't infringe. That's a very important distinction to maintain, and it's one reason why it's important to keep records of the things you create, so in case you're ever accused of copyright infringement, you can go back and say, hey, wait a minute, I didn't infringe your stuff. I can show you that I came up with this on my own. Before you can sue someone for copyright infringement, you have to register your copyright with the U.S. Copyright Office. And when people say, can I copyright it, that's typically what they mean. It can take a long time to get a registration from the U.S. Copyright Office. And if you think that your work is something that's important and you want to protect it, you're better off seeking a copyright registration at the outset instead of trying to wait until you find someone who's infringing or copying. You want to do it as quickly as possible, and it's a pretty straightforward thing to do. Now, a couple of practical things about copyrights that seem to generate a tremendous amount of confusion. Just because something is on the internet does not mean that it's free and that you can copy it. If you right-click something on the internet, it very well could be a copyright infringement because you have copied somebody's copyrighted work. So it's very important to keep that in mind. What we find that a lot of people also do is that they go to websites and they may think that what they're downloading is free to download because the website may say, you can download our materials, go ahead and do it. But what the person doesn't do is to read the fine print as to what that means when you download and what you have to agree to. And whatever that may be, it may say that you have to give certain attribution. It may say that you have to pay something if you keep it on your site for more than a longer period of time. It just depends. You have to read that fine print, because if you don't go along with that fine print and go along with the terms of use that you agree to by clicking on the image, then you become a copyright infringer. So it's really important to note that, again, just because it's on the web, it doesn't mean it's free. if you put your stuff on the web at the same time, you want to post your video to Instagram, you want to post it to TikTok, you need to read those terms of service very, very carefully before you post. So for example, you post to one of these social media sites, that fine print may say that they now have the right to do what they want with what you posted. Maybe they can license it to someone else and make money off it. You just don't know without reading it. So you just want to be very careful before you take someone else's stuff off the internet or before you post any of your own stuff to the internet. We always recommend, too, that when people have their copyrighted works, that they put a notice with it. A very simple notice. All it has to say is copyright Circle C with the year, by, and you put your name. And it puts people on notice that you are claiming a copyright in that particular work. You want to do that so that if they end up taking it or copying it, they can't say, oh, gee, well, I thought this was okay for me to do. I thought they gave permission. I didn't realize it. You want them put on notice that you consider this to be your copyrighted work. So if they take it or want to take it, they need your permission to use it. And the copyright process, once you get the copyright issued or granted by the Copyright Office, you don't have to renew it. It's a one-time thing. It's done. There are provisions for older copyrights for renewal, but for the ones that are coming up now, they last for a very long period of time, so you're good to go once you get it. Again, it's the kind of thing that you should consult with an attorney on, at least at the outset, and especially for software copyright applications. But for the most part, some of the more simple ones, you can probably do yourself by following the online instructions on the Copyright Office. And with that, we are able to answer any questions and answers that anyone may have. And we also want to remind people that there is a brief survey at the end of the presentation that we would like you to complete. It would be very helpful for us if you could complete it. And there's a chat box for questions and answers. So please, if anyone has questions that they want to ask of us, we'll take the remaining time and answer them. And if we run out of time, you can always submit them and we can answer them by email afterwards.
Yeah, I was going to say, I mean, it looks like we had one, and I think, Michael, you did a pretty good job, pretty thorough job on the provisional patent. The question is, how does the provisional patent work? I think it looks like we have a couple of minutes, and the only reason I'm rushing is that I think I've been told that this is just going to cut off at the 1 hour mark. So Michael mentioned all this, but I would reiterate on a provisional patent, they can be of value, but they are not a foolproof thing where you can just sort of submit any old thing and you now have locked in your rights. Because if you just sort of submit, a PowerPoint presentation or just like a few paragraphs, that may not ultimately really do you any good, and it may not save your spot in line, so to speak, because you when you write your non-provisional that is linked to your provisional, your provisional has to be able to sort of encapsulate there has to be a link that you actually have this invention when you submitted the provisional. So it has to be thorough enough that can be sort of discerned. And so, I think a lot of times people think they can just sort of submit whatever as a provisional and they feel good about it, they have a patent on file, but ultimately it may not really be worth much at all. So, be wary of that. I think that's a common misconception of provisional patents. So I would just add that. If there's any other questions coming in here, we're happy to answer them. If not, thanks. And I would say you can contact Michael or me. I'm talking for Michael here, but he's a great guy, so he probably won't mind. You can contact either of us directly if you guys have any sort of specific questions, IP related. We'd be happy to answer any questions. All right, well, it looks like I think we're give it another minute here, and if there's, feel free to, you guys can ask whatever you want. And if not, thanks for your time.